Yeah.
Thank you, everyone. My name is Dr. Gary Joe Ford, and welcome to the Data Unit NASD Public Community Meeting titled "A Jury of My Peers," a brief discussion on issues of race and equal justice. Tonight, we're going to have the chairman of our Legal Redress Committee to moderate this session. He's going to introduce his guests, and we're going to get engaged in the conversation.
Good evening, everybody. We appreciate being here. We appreciate the people that are tuned in by Zoom and Facebook. This program at a point of departure, back when we had the judicial candidates here from Montgomery County positions, and Tom Roberts posed the question to those candidates: how many of you read the new Jim Crow? And the answer among those candidates was one. That candidate is with us tonight. I'm sure she'll have some comments along those lines. But then led further to a discussion in an executive committee meeting. Really, the thought was initiated by President Forward. He said, "What is the jury of my peers?" He said, "I consider those of you sitting around this table to be my peers. But is that who I get if I go to trial and there's a jury?" That led to a lot of conversation and the thought that we need to discuss these kinds of issues in this kind of a forum. So we're very happy to have our guests here tonight. Let me introduce them. First of all, let me introduce Judge Stephen Dankoff, who's a general division judge here in Montgomery County. He was appointed by Governor Ted Strickland in December of 2010, re-elected in 2014, re-elected in 2020. Sadly, he won't be able to run again because of the age limitations they enforce in this state. He got his BA summa cum laude from the Ohio University and his JD with honors from the University of Texas at Austin School of Law. He initially practiced with a law firm that some of us old guys remember by the name of Smith and Schnake, which was later subsumed into Thompson Hine. And it was the kind of firm that had the best lawyers, the best clientele, a lot of areas of practice. That firm was swallowed by Thompson Hine, and it led Judge Dankoff to depart and go into a smaller firm, private practice, and did a lot of plaintiff's work, a lot of defense work, a lot of small business work. And he took that background. To the courts. And we have a good tradition in this county of practitioners who've been who've worked for many years becoming involved as judges at a later time. So Steve is an example of that. Judge Dankoff is, and we welcome him tonight. Secondly, we'd like to welcome our newest judge in the Common Pleas Court, and that is Judge Angelina Jackson, who was elected. She is the one in our meeting that knew all about the book that we should all know all about. Okay. I'm out of camera range. That's okay with me. At any rate, she is homegrown, and we love to point out, Dayton Public School. She went to Florida A&M. She is our resident. And she went to law school at the University of Cincinnati. She practiced law at Dinsmore Joel, again, a larger firm setting. She did civil litigation. And then she graced the public defender's office by coming there and practicing law for the indigent in appointed cases, and was a major force in the public defender's office until she chose to run for judge. We have a history of prosecutors being elected to the bench. We are all so proud to have had a public defender elected, and it brings the perspective we badly need. So we're glad you're a judge. Next, let me introduce our former state senator, our former bailiff in the common police court, which gives him a wealth of knowledge and topics we want to talk to tonight. Tom Roberts is a graduate of Chaminade High School. The University of Dayton, he obtained his bachelor's degree. He was a bailiff in Montgomery County. All of us that were around remember him as the best bailiff. That's not lone folk, that's the truth. He was a bailiff to Judge William Wolf for at least 10 years. You'd have to tell me how long, Tom, I couldn't find that. But later, he was elected to the Ohio House and served from 1986 to 2000, and then to the Senate from 2001 to 2008. Among the legislative initiatives that he sponsored was the Ohio Brownfields legislation, which deals with cleanup of industrial sites, which was model legislation nationally. On September 9th, 2017, he was elected. At that time, he was second vice president, as he is today at the Dayton Unit, but he was elected president of the Ohio Conference of the NAACP. Re-elected in 2019, re-elected in 2021. Running again in 2023, and we all support him. He's done a magnificent job and raised the profile of the state organization. So Tom really needs no introduction to this group. He's been a valuable go-to guy in the Dayton Unit of the NAACP. Finally, but not least, another Bobcat, another Ohio University graduate, Attorney Dave Williamson, who graduated summa cum laude from Ohio University, Ohio State University, I'm sorry, from Ohio University, and got his law degree at Ohio State University in 1978. He's practiced law as a magistrate back when we called them referees. He's practiced law as a public defender. He's practiced law in criminal practice and civil practice. And there are few lawyers in this town ever that have the breadth of experience and knowledge of Dave Williamson. So we're very pleased to have him here. His practice included business litigation, commercial litigation, construction litigation, and related matters. He also has great experience in police matters. He has represented police officers. He has represented individuals abused by police officers. He has special knowledge in that area. We're going to tap into that a little bit tonight. So this is our panel. We welcome you all. We appreciate the opportunity to have you here. To start this out, our point of departure was this jury of my peers. And the thought that how do you define peers? And is that somebody who is from the same community? How large a community? How small? How is that interpreted by the courts and in the law? And what other safeguards exist to allow you to have something that looks more like you on your jury and to not exclude people that look like you on your jury? So I would first like to turn to you again, Judge Jackson. Could you talk a little bit about how the Common Pleas Court responds and how those issues are dealt with by the courts?
Well, I think it's important, at least at the outset, to sort of put the issue into perspective. You know, we have a lot of conversations about representation and why that matters, you know, in terms of the community's faith and trust and confidence in the local legal system. And so when we talk about a jury of your peers, our peers, we're talking about a jury that is like a representative cross-section of the community. And, you know, what we typically talk about in a lot of these conversations is the lack of representation of people of color in jury pools and on juries. And I read something in advance of tonight that I thought was really interesting about why this is really important. And this was something that the Equal Justice Initiative wrote about. And, you know, people of color are significantly underrepresented in a lot of positions of power stages of the criminal justice system, police, prosecutors, judges. And so the absence of representation of people of color means that decisions about like who to arrest, what kind of crimes to prosecute, and how to punish people are made primarily by individuals who have less experience dealing with racial bias. And so when we talk about jury service, what the Equal Justice Initiative observed and what I agree with is that jury service is often the only opportunity for a true community perspective to impact the outcome of cases in the American legal system. And so that kind of puts the issue into, that's a broad perspective on the issue. We are subject to certain constitutional mandates in terms of how our juries are made up. I guess the makeup of our juries is the way to say that. The law, we are subject to, let me back up. In the process of selecting a jury, and I don't know if this is where you want me to go, Gary, okay? All right, so for those of you that have never participated in a trial, there is a process by which attorneys question prospective jurors. It is the attorneys in a case who pick the jurors, okay? And they have an opportunity to remove jurors. There are two types of challenges. One is like for cause, that there is like a specific reason why a person is not fit to serve, for lack of a better word. And then something called a peremptory challenge, which is where an attorney can remove a juror really for any reason. They don't have to state the reason. And so, prospective juror rather. And however, what we cannot do and what is constitutionally prohibited is that attorneys may not strike jurors based on race, ethnicity, other protected characteristics. I'll go there in just a moment, but that was decided by a case, Batson versus Kentucky. And so when, how we deal with this issue in the court is that if an attorney feels that a juror has been removed by a peremptory challenge for an impermissible reason, then they can raise a Batson challenge. And that essentially consists of three things that happen legally. The first thing is that the challenging attorney has to make what's called a prima facie case. They have to show that the facts and circumstances raise an inference that the juror was excluded because of race. And then the burden shifts to the prosecutor to offer a race neutral reason for exclusion of that juror. And historically, I mean, that really can be pretty much anything. So a lot of times, I guess, this would be where the challenges really fail, because there are lots of race neutral reasons that courts finds to be acceptable. But the third element would be then if you did get past the second of whether the defendant has established like purposeful discrimination, or that the reason offered by the prosecutor is a pretext, which is like just like fake or a lie, for lack of a better word. And so what that does is the third element puts the court into a position of evaluating the credibility of the prosecutor, essentially. That's what happens. But so Justice Thurgood Marshall agreed with the decision of Batson, but he wrote what's called a concurring opinion. And basically what he said is that this test was not going to reduce racial bias in juries, and he was of the perspective that these peremptory challenges, these ways to strike people for no stated reason whatsoever, that they should be eliminated entirely. And there's lots written about that. There are a lot of people who advocate that. And later on this evening, I'll talk a little bit about what at least one state has done to as an alternative to Batson, because really there are a lot of opinions that Batson is not adequate, okay, to address issues of potential racial, ethnic bias. And also, you should know that it does cover sex as well. So there's a case, the exclusion of women from juries, and this rule applies in both civil and criminal cases. So that's kind of your background summary there.
So in theory, you can't strike a juror because they're black, because you don't want black jurors, which has been a practice for eons. But a pretext perhaps can allow you to get away with that. So we have a long way to go. Okay, let me go to Tom Roberts. I don't think there's anybody that I can think of that has seen more from the litigant, from the criminal defendant standpoint, from the lay standpoint around the courts, where the rest of us lawyers or judges here. Tom was a bailiff, Tom's a state legislator, he's seen the mischief over in Columbus, and he's seen the practical application of these situations to folks. Tom, could you share some thoughts from the perspective of people who go into a court and don't see anybody that looks like them?
So Gary, let me begin by saying publicly, my sister was a bailiff too, so she was probably
That's
the greatest
right.
bailiff. Publicly, I'll tell you something else, because I think she might be watching. And I think when I started, Judge Fisher is an African American. He had a bailiff named Matt. And then Doc, I think he was a pharmacist, and he was a visiting judge, a bailiff. Then I came. And I think Mary, who was Carl Kessler's, Mary Hardy was Carl Kessler's bailiff. And then me, and then Michelle. I don't know if any other. And unlike what we see on TV, who's that? Bill Cook. Bill Cook, see, that came out of me. Yeah. And so unlike what we saw on TV with Matt, you know, and Rusty, the Court of Common Pleas bailiffs were like administrative assistants to judges. And their cases is called their docket. And so we help them administer the docket by setting up pre-trials, by making sure that everybody was supposed to be in the courtroom was in the courtroom, the attorneys. And then we were assigned to take care of the needs of jurors. And let me say this, because and I asked Michelle about this earlier in the day. Jurors are selected from the Bureau of Motor Vehicle and the Board of Election. And early on in my career, it was just the Board of Election. And people stopped voting because they didn't want to be on jury duty. So then the legislature moved it to the Bureau of Motor Vehicles also. So I think today, how you become a juror of your peers is by voting and by drivers and by driver's license. It then goes into a jury commission and by lottery. The names are pulled out. Now, how they do that, I've never, it's been 20 years ago. I was a bailiff from 75 to 86. So it's been many years, but I think that's still the way to do it. So you become a juror by voting and by the Bureau of Motor Vehicles. And I'd like to hear if your license is suspended, you know, if you're taken out of that pool, that may be another concern of ours as we talk about voting. But it was very interesting. And I would say back then, and maybe it is today, Michelle confirmed this, in the 90s, most people, once they got in the jury and experienced it, they enjoyed it. I think they were on call for 3 weeks, as I recall. So you were assigned a judge. And so the jurist, Snoopy says, you know, you get a call, wait around, and you never get called. Some people feel that way, but you're on call for 3 weeks. But only people that are really, many people that realized that didn't want to serve in juries were people who worked on business because they didn't take off work and I don't pay, which wasn't a large amount then, which was a little stipend. And write PAT, because some people write PAT always said they were essential services and didn't want to take off from work to do that. And you're right, Gary, it's just interesting watching jury. What I can say it, all rise, please. You know, I can say that little line, all Judge William H. Wolf Jr. presides. That was my spiel every day he came into the courtroom. But this goes to another topic I should, because I think the three of these individuals, being lawyers, have a lot more. The jury box, when it's not used for jurors, it's where the people from the county jail can for their day in court. And some are wearing the orange garb. From my experience in 75 to 86, it became more blacks in jury box and more women. And I didn't know what was going on. That was just sad. Every morning, Monday morning at 9 o'clock, to look over the jury box and just see, the amount of people. This goes to when Judge Dankoff was working, was on bail reform. The amount of people who could not get out to, but had to come and sit in the jury box. I saw more people of color and more women, younger, coming to the jury box at that time. So it was a fun experience. I would say if you ever call for jury duty, accept it as part of my civic responsibility. And not every case is going to be killing somebody or petty theft. It could be a nice little civil case, where somebody wrong, you get to help correct it. So my experience was good, but I think the judges here, they could share a lot more from their perspective.
Thanks. I've yet to talk to a juror post-trial that didn't enjoy it. The judges would have a better handle on that, and Dave has his own experience. But let's transition straight over to Dave Waits. Dave has great experience in police issues. He's represented police in civil lawsuits. He's represented criminal defendants charged with resisting arrest. He was appointed a special investigator after a particularly serious public event in a Greene County village on New Year's Eve. And he investigated that, all about police stops, traffic stops, police response calls. And the question comes up again. President Roberts suggested this in our earlier conversation. Why don't we help people understand how they should conduct themselves at a traffic stop? So Dave, we turn to you, the most experienced person here, to talk about those stops if you can, how they are handled, what occurs, and what advice you have, please.
Sure. You use the word traffic stop. I need to make clear that there's really two kinds of stops. A traffic stop is a very different breed of cat than a police interaction. Let's say that somebody calls the police to come to their home or their place of business or somewhere. And here's why that's different, is that the law is very clear of what a police officer may or may not do as far as his or her interaction with a member of the public. A police officer may only arrest for a misdemeanor or a felony that he or she personally witnesses. They may arrest for a felony that they don't witness if they have what's called reasonable suspicion to believe that the person committed a felony. So with a traffic stop, it is implied, you can just about count on it, that the police have or will later say that they observed some sort of traffic infraction. Maybe it was a taillight that was out. Maybe they saw one wheel go on the center line. Maybe they were doing 37 and a 35. Something that gives them the legal pretext to stop your duty. And then that then creates a set of guidelines for them to follow from that point forward. When they're called, let's say that they're called to your home, somebody calls them, and they arrive, they've not observed anything illegal at that point. And again, here's the couple of things. When a police officer asks, you are required by law to answer and give your name, your address, and your birth date. If it's a traffic stop, you are also required by law to show your license, your registration, and your proof of insurance. And the passengers in the car can be asked their name, their address, and their birthday. That is all you're required to do. It's all you're required to say. You have the absolute right to remain silent. And it's free country, you don't have to talk to anybody other than what I've just told you. Those are the legal requirements. If you don't give that information, then you can be subject to a misdemeanor prosecution for failure to follow a lawful directive from a police officer. In a traffic situation, there's a bit of a bigger concern now, because as of June of 2022, it's only been in effect now for 7 months. And that is a brand new law regarding the ability of anyone to carry a loaded firearm in their motor vehicle. Didn't used to be that way. So now police officers are now especially on their guard when approaching a motor vehicle to confront a citizen whom they've pulled over as to whether or not that person may be armed. And remember, the new law says that you may carry a loaded firearm on the front seat of your car if it is open, if it is visible. If you are carrying it concealed, the old law required you to tell the police officer, I have a loaded firearm in the car. You no longer have to do that. So expect a police officer to ask you to step out of the car. That's the best thing for you to do, because you don't want any misunderstanding as far as him or her being concerned for their safety and you being concerned for yours. Whether it's a traffic stop, whether it's a non-traffic stop interaction with the police, best advice is to, number one, not argue. Number two, if you don't have to say anything, but don't put yourself in a position where the matter can escalate. Well, that's difficult, particularly when you're talking about racial interactions between police officers and citizens. But so many times, someone might want to explain their position as to what just happened and treat the police officer as if he or she is a judge or a jury in a courtroom. If I could just tell you my story, you'll see that I'm right, and you should pay your attention to this other person, or let me go, or something else. That generally is not a good idea. I have two very, very fine judges here to my left, and that's their job, is to separate the wheat from the chaff. So it is generally the best idea to be businesslike and to put a police officer at ease. Just like everyone else, there are good apples and bad apples. Most of the police officers do a fine job of protecting us and enforcing the laws. Some police officers, as was demonstrated with the George Floyd case, are not looking out for anybody's interest but their own. So you don't know which kind of police officer has stopped you. So you've got to play it smart. And again, my advice is always don't get into a situation where there could be trouble. The biggest thing that my editorial comment is that we need stronger accountability for police misbehavior in actions. Dr. Forward talked about this most recent situation here in our community. And again, I can only comment upon what I see on the television. There is no excuse, there's no justification for a police officer to punch this woman under the circumstances that were at least visible in that tape. Now, I caution everybody, we have to wait until all the evidence is in. That's what we do in my profession. But at first blush, there's no excuse for that. What's the accountability? What is there an internal affairs investigation? Should there be a citizen body? Should this body be involved in somehow holding the police officers accountable? What is that? I have spent some of my career in representing police officers who get sued in civil cases for their misbehavior. And but that's civil cases. What about the issue of suspension without pay, placed on administrative leave? Who's investigating? Is it the police officers, fellow officers in that department? Is it another department? Should somebody else come in, like a special prosecutor, something like that? Those are all questions that we as a community need to address. So it's more than just the confrontation of citizen and policemen on the street. It's also the accountability afterwards.
Thank you, Dave. And I guess that firearm in the front seat is one of those, some of that legislative initiative that we've talked about. As the law of Ohio continues to move in a certain direction. If you have questions, this lady over here in the green vest has little cards and pens. You can write them down. Come up to us. We'll try to get to all that stuff too. We appreciate that. Now, we've got two judges here, but judges can't just say and do anything they want. You can't. Judge Dankoff, I'm here to tell, that's what I heard. All right. Rule 2.10 of the Judicial Code of Conduct says a judge cannot make public statements that might reasonably expected to affect the outcome or impair the perception of fairness. The judge shall not do anything that's inconsistent with remaining appearing impartial. So a judge's free speech is restricted. Lawyers' free speech is restricted as part of the mandate that goes with the privilege. Further, 4.1 of the same rule says in connection with cases, controversies, or issues that are likely to come before the court, a judge can't make pledges, promises, or commitments that are inconsistent with impartiality. I think we heard, nobody here has ever done that, but I think we heard a little bit coming very close to that line in this past election. Knowing those kind of limitations, I'd like to turn to Judge Dankoff. Judge Jansen shared her perspective on certain matters at the candidates night. We talked about the new Jim Crow, the book and the theory and the problems. I know Judge Dankoff has strong opinions. And we know there's a line, but what can we look to for judges? What kind of leadership and strength? We elect people like these two because they're leaders in our community. And we need their leadership. We need them to speak out on issues. And we've discussed this in advance, but the Fraternal Order of Police filed a formal complaint against the Common Pleas judge because he hung a picture in his courtroom of George Floyd. That matter got investigated. This is out there because somebody tipped Channel 7 and it wasn't Judge Dankoff. They made a story out of it. It was the cover of New York Magazine of Mr. Floyd. And that matter went forward, and I know that the judge spoke strongly about that and spoke publicly about it. Those claims were baseless, but I'm going to let Judge Dankoff speak to that. That again is a big collision between racial issues and the justice system. Can you comment on it?
So I was a trial lawyer for 35 years before I became a judge. And I have an impression of the courtrooms. And that informed what I did in this instance, and we'll get to that in just a second. Courtrooms, in my opinion, even when you're a lawyer, are places of great dread and foreboding. They are not friendly places. They're scary. And when you become a new judge, you take some training that the Supreme Court puts on. And one of the things you take training on is procedural fairness. And one of the things they train you right out of the gate is they tell you about the Alaskan State Court Fairness Pledge. And it's this pledge that they have up in Alaska, and where you promise the people that come into your courtroom that you will treat them fairly, you'll treat them with respect, you'll answer their questions regarding the procedure. And in essence, we're going to get through this together. So I was shown that at the new judges training, came back to Dayton, promptly did nothing. I was in good company because no other judge has ever done anything about that, Dayton. I then saw that pledge at a subsequent training in Miami, procedural fairness put on by the National Judicial College. I saw it again in Santa Fe, and mindfulness training for judges. And finally, because I had become mindful, I came home and I said, I'm gonna do something about that. So I had my daughter who studied in Spain and taught an indigenous orphanage in Mexico, translated it into Spanish, and I had it fabricated by our maintenance department. And so the Fairness Pledge is on the door to my courtroom. And it's in English and it's in Spanish. Why is it in Spanish? Well, we have a large Hispanic population in Dayton, but more importantly, what's the inference? If you're not an English speaker, and you might not be a Spanish speaker either, but you recognize there are two different languages, don't you? And so maybe you speak Russian or Turkmenistan, Arabic, whatever the case might be, Farsi. You know that the judge then is saying to you, if you're not an English speaker, raise your hand. I'll get you an interpreter. I'll get you a translator. We will treat you fairly. I was trained in that Fairness Pledge by a judge who used to be a common pleas judge in our court. I've known him for 45 years. He was on the Court of Appeals in this town. He taught the pledge at the new judges training. One day he was wandering the halls of the courthouse and he saw that pledge. And he came into my office and he was really excited. And he said, he saw it on my door. I said, well, Judge, you're to thank for this because you're the person that exposed me to it. And he said, well, what are the other judges putting it on there for? And I said, well, Judge, I don't know. And he said, what do you mean you don't know? And I said, well, I did it on my own. And he said, well, wouldn't it have been better to wait till all of the other judges did it too? And I said, I'm not going to live that long. Okay. So the point being that judges should embrace that what we do in those walls of the courthouse is scary. And it's foreboding, it's different, it's unusual, it's misunderstood. And we have an obligation to you. I work for all of you. Jackson works for all of you. To do your bidding. You shouldn't the courtroom say to you that all who enter are welcome? Now, in my courtroom to expand, I have a portrait of Frederick Douglass that looms over my right shoulder. I have portraits of Eunice Grant, William Tecumseh Sherman, Ohio's favorite sons, who defeated the Confederates. That would be the traitors that tried to bring the boy into the Union. That would be Eugene Company. Do you know who he is? He's the Capitol police officer. 6 insurrectionists that broke the Capitol. They were there to hit Pelosi. And make no mistake, okay? Mr. Goodwin led the murderers away the well of the Senate and saved the lives of those representatives. And yes, George Floyd was murdered. He was murdered, make no mistake, he was murdered in Minneapolis. I read an article by a federal judge named Jeremy Stoll. And Judge Stoll, he was also now at the Berkeley School of Law. The judges had a responsibility to ease the suffering George Floyd's murder had visited upon. I took that seriously. I took that New Yorker cover. Jared Nelson is an African-American artist in Los Angeles, famous for his Negro League paintings primarily. And I had it framed and I put it in the courtroom to do what? Say that that sort of behavior wasn't going to be countenanced, at least by me. Okay. So, yes, the police were upset with me. Who was the person who complained about me? It was one of my fellow judges. She dropped my judge disciplinary council. And they told me they saw the take a picture. I said I would never voluntarily. And ultimately they dismissed the proceeding against me because you know what? I was standing when Mr. Ludlow read you about the canons that say judges can't do certain things. We got something called the First Amendment that trumps whatever those judicial canons say. The First Amendment says that I, all of you, have rights to political free speech. Judges don't get that just because they be judged. And I absolutely have the right. Now, is there a case where I might need to take it down? Well, you can imagine one, couldn't you? What if a police officer was charged with brutalizing? What if a police officer was charged with brutalizing a black citizen? Would I leave that picture up? That case? No. That. So from time to time, it might be inappropriate given a particular case. The whole exercise was to do what? Create a tone, create an atmosphere in the court. And it works. And I can tell you how I know. Because we had a jury not too long ago, an enterprising young prosecutor said to the people, they wanted them to look around the courtroom, look at all the things I had hanging. I got a picture of Cesar Chavez hanging in the courtroom. Hero of mine. Bobby Kennedy, Clarence Darrow, we got all kinds of stuff in there. And they asked the people, give us one word to describe the court. And he picked on the lady sitting in the front. She happened to be a woman of color. Going back to Batson challenges that Judge Jackson was talking about. He was trying to figure out a way to get her off that jury. And she looked around the courtroom and she said, I get one word. He said, one word. She said, welcoming. She got it. It worked. She got it. He didn't bother trying to strike her. So he knew the kindly Judge Dankoff would have said, no. Okay. So that's why I did what I did. Do it again, welcome the opportunity.
Thank you, Judge. And the expression of making people feel comfortable in the courtroom is something we don't hear when those types of things occur in their defense. So we surely appreciate it. Good. You can all see how much fun it is to work with the justice system because of these kind of issues. Judge Jackson, you mentioned, and we've got these questions, we'll get to them, and traffic stops are a big topic. Excuse me. Judge Jackson, you mentioned some initiatives in other jurisdictions about this question of what is it, jury of peers, and it's somebody in your community, but that doesn't mean you get to pick the West Dayton community as your community for a jury. But there are other initiatives. Could you share that with all of us?
So, the good thing, even though the ethical rules say that there are lots of things that we can't talk about, we can engage in public education. And I'm like a huge research nerd. I love to look and see what other places are doing to address the issues. And then relay that information to people in the community. Because ultimately you all are the ones who are selecting our leaders. You're out there advocating for the kind of changes that you want to see in the system. And so the more information you have, you can be empowered. I just want to go to the issue of a jury pool. The Sixth Amendment does require that you have this representative cross section to pick from. But the problem is that, like, by and large, there's really no teeth in the law to like enforce that if it doesn't happen. And so I think New Mexico, and I could be wrong about that, but there are states who are starting to draw folks for their jury pools from other places. So in addition to like the driver's license database, they're looking at like state income tax rolls. They're looking at public benefit, people who receive public benefits. And another thing that happens is a lot of the jury summons will be returned undeliverable. And this is, because lower income people tend to move a bit more frequently. There are also some initiatives whereby courts are doing things to try to verify an address before a summons is sent out through like a change of address database. And so as I can't tell you, how successful that's been, but just based on, where the information is coming from, it seems like it would be a lot more likely to get more of a cross section of the community. We're obviously not doing that in Ohio, those things. And then I want to go to the issue of the vaccine challenges and this whole 3-step process that is set up by the case law. So, what the state of Washington elected to do is to come up with a rule regarding jury selection. Because remember what I talked about, if you can offer race neutral reasons, then typically that will be enough to muster. So what the state of Washington did a few years ago is they put together a rule that says that certain things are presumptively invalid reasons for a peremptory challenge, okay? And these are things like having prior contact with law enforcement, expressing a distrust of law enforcement, or believe that law enforcement engages in racial profiling, having a close relationship with people who have been stopped, arrested, or convicted of a crime, living in a high crime neighborhood, having a child outside of marriage, so I feel like on a jury nowhere, receiving state benefits, and not being a native English speaker. So while these are like obviously race neutral reasons, which really, not, but often as race neutral reasons, this rule said, no, you cannot use these things. Additionally, one of the other things that comes up, say what about this or not, but observations of folks' demeanor and their body language and things of that nature. So what they did is they said that there are certain things that were historically associated with improper discrimination in jury selection in the state of Washington. And they said that these certain things, they're like allegations that a juror is sleeping or inattentive, staring, failing to make eye contact, exhibiting a problematic attitude, body language or demeanor, or providing their language is unintelligent or confused answers. And what the rule says is that if a party wants to offer one of these reasons or a similar reason as a justification for a peremptory challenge, that party has to provide notice to the court and the other party so the behavior can be verified and addressed in a timely manner. And if there isn't corroboration of the behavior by the judge or by the opposing counsel, then that rule is invalid. It cannot serve as the, justification. So again, the hard thing about things like these issues, is that, ideally it would be great to have data to know how well or not well we are doing with these things. But studies are expensive, and the only study that I am aware of, in recent times that's done on the issue of this, the makeup of juries is something by North Carolina. So there's really not much I can say about the state of Ohio. But what I can say is that in jurisdictions where, folks are willing to, maybe think about alternative ways to address these issues, you have something like this rule. So can I tell you how well it works in practice? No, I don't work there. But what I can say is that it seems to address the concerns that have been articulated, surrounding the inadequacy of Batson, to prevent individuals from being struck from the jury pool for impermissible reasons.
This is where I get to exercise my power as judge. I'm just kidding. Judge Jackson is absolutely right. Now, one of the things that she hasn't said because she's too polite, so I'll say it. Okay, that's this. Judges, Ohio is not in the vanguard. Can we agree on this? Ohio is not in the vanguard of judicial jurisprudential development. We're not. Okay, we're not Illinois, we're not California, we're not New York. We're kind of backward, to tell you the truth. And we do a lot of things in Ohio because it's the way they've always been done. And that's no reason to do anything, is it? Now, on this Batson thing that the judge was right to talk about, the arguments, the reasons that somebody wants to strike a person, Judge, I want to strike juror number 8. Juror number 8 happens to be a person of color. The defense lawyer representing a person of color objects. Says, I assert Batson, this is obviously an attempt to strike a juror that looks an awful lot like my client. I object. And so as the judge, he turned to the prosecutor and say, what's your reason for striking this juror? Well, they were yawning when I was asking questions. And as a judge, and I probably shouldn't do this, but I've done it. I've said on the record, everybody was yawning when you were asking your questions. Not just the person of color. I said, I was yawning. So I have routinely, routine is the wrong word. I have regularly refused a peremptory challenge on that basis. It's pretextual, it's nonsense. Move on. And I think one thing that many of you here, I hope, remember the great Carl Kessler. Senator Roberts certainly remembers him. I do things now after 12 unfilled years on the bench. I do things now that I would never have done when I was first on the bench, because I was fearful that I would be painted as a liberal or a progressive. I mean, I'm a liberal, I'm not a progressive. I don't know what progressives are. They're people who don't want to admit they're liberals, I guess. So I'm a liberal. And I do things now that I never used to do because I'm comfortable doing it. Because I'm comfortable, it's the right thing to do. And that's some challenges. I think more of those challenges should be sustained because they are what they are. Mr. Williamson talked about traffic stops. And I wrote a decision. It's known affectionately in the legal community as the dark and stormy night decision, where I threw out an motion to suppress hearing, a stop of a black motorist. And it was apparent to me that they stopped the motorist because he was black, period. And the explanation for the stop and why they stopped him did not hold water. It was untruthful. Now, here's the drill. You can get stopped, as Mr. Williamson points out, for just about anything. Your license plate light is out, you only got one tail light's working. You didn't signal a turn within 100 feet of the turn that you, all kinds of reasons. Are they stopping you for that, really? You know better than that. They're stopping you because they want to stop you. And what do they want to do then? They want to go on a fishing expedition. That's what they do. And they know what they do. I mean, I've been stopped for reasons that are completely pretextual. But the reason Mr. Williamson was right when that happens. And by the way, as you might have guessed, a little bit we've been together, I have anger issues. And but because I'm the judge, I get to have those issues. But I don't get angry with law enforcement. It's a bad career move. Okay? And you know, they're trained, Mr. Williamson hasn't said this, but I'll tell you, they're trained in something called the force matrix. Here's how it works. If you give them any attitude, they escalate. They escalate. If you escalate from there, they bring it up another notch. And sooner or later, it ends badly. So even I, with my anger issues, when I get stopped because I left Marion's Pizza in Oakwood, well, strike that. Marion's Pizza that I go to is in the city of Dayton. But when I return to my little community, Oakwood, and I go over the little bridge, I go from a 35-mile-an-hour speed to 25, like that, right? And I've been stopped. I've lived in Oakwood since I was 16, and as you can tell by the color of my hair and the absence of it, that was a long time ago, okay? So when I get stopped, I'm angry. Why? I think to myself, how stupid can I be? I got stopped again leaving Marion. I mean, I've been stopped 6 times over the years leaving Marion's Pizza because I'm driving too fast. So I'm angry. But when the officer comes to the window, I dial that down because that's the best thing to do.
I hate to tell you that I've been stopped, and I live in a rural community, some of you may know, but I sued one of the police departments down there for officers and for citizens. And in fact, it was reported to me later by an officer in that department. The chief told them to look for me. They knew my way home. And it's not a densely populated area, so it was easy.
I know.
And so, yeah, if I had a couple of beers, I was not. Anyway, let me go down here to Tom Roberts. Feel like Bill Donahue, right? Tom, among the questions, there's a lot of interest in this, what is a peer and the traffic stop issue. Particularly, and I would love to hear from your perspective with your experience, if I get this court. Thank you. Do you think that not understanding the process of jury selection and the role of jurors contributes to underrepresentation of jurors of color? And is there a stigma about serving as a juror that interferes as well? And the question is also asked, define peers. And this feeds into some police issues and some stop issues that we'll go to next. But very good.
Well, it's several points. Apparently, peers means anyone in Montgomery County, in this case. You know, and so it's not, it suggests it's not West Dayton, it's anybody who lives in Montgomery County. That's why many of us don't understand how it becomes here. That's why I said it's through the Bureau of Motor Vehicles and voting. That's how they get the pool of people. And they put the pool into a container. It used to be something they turn, maybe they do a computer by now. But it is a pick of the names of the people in that pool of jurors. I don't know, sure, Gary, there's different topics, and that's why I was concerned about, you know, so I don't know how I get these apps. If I get these apps where people are stopped, speeding or something, David, and the police officer says, give me your driver's license and roll down your window. I refuse to roll down my window, you know, or they turn it on just a little bit so they can see, and then it escalates. Give me your driver's license. I don't give you my driver's license, and this is why I was asking Gary to have these council members talk about this, because I got people watching this. And they think if a police officer said, give me your license, they can say, I can't give you my license, I don't have rights. Well, apparently they're in a different state or different zone, this is why I'm glad David said what he said, and the judge said, it's gonna escalate if you don't, and that's what happens. And they say, well, I'm not gonna give you my license, so you don't know your rights. And so for me, that's what I was trying to at least get the answer, is that when you stop, give them whatever the law says and let the judge sort it out in the courtroom. And because all you're gonna do is escalate and you're gonna end up in jail. Now you've got another charge, I assume, resisting arrest or something else. I mean, it's just multiple. I guess that's why I was asking the question here to do that. But for me, it's been anybody, as I said, anybody that served on the jury, even when they have not wanted to initially, their experience was great and they enjoyed it. And here's the last thing I was using closing argument, we're getting close to that anyway, closing comments. The courtroom is a public building. You can go there and sit down and watch the proceedings. I would encourage you to do that. The voters used to have something called court watch. I don't think they have it anymore. But I would encourage you, that's your house. As Speaker Wright would say, as Judge Wolf and look, I've talked about Carl Kessler many times in this building. And I think some of our judges need to go back and read what Carl Kessler and C.J. McGlynn did when they were working together. Some of the judges need to have that courage. And I point to Judge Dankoff because I'm working with him right now on bail reform issues. And it's something that if young people, if a person can get out of jail, they can talk to their attorney. They can work their defense. But you're sitting in jail, you have to go through all kinds of hoops to get there. So we do need some bail reform. I'll come back to the new one with that. Yeah, I think I answered some of that.
Thanks. Really, the last of the questions that we were given all had to do with traffic stops and police interaction. I neglected to mention that Judge Jackson served on several police review committees, and I don't know if you still do or if you can in your current. You can't now. But it was a very important thing that she was on that as a public defender, particularly. But for example, we're asked regarding the traffic stop, are you required to get out of your car? What do you do? Can a police officer search your vehicle without a warrant? There's no visible drugs. How do you educate the community better on the laws when interacting with police? So many people do not know that it is the law to provide your name and give your address, especially if you feel you've done nothing wrong. One person says, thank you, Judge, for reminding us that the action of law enforcement should be monitored. Are citizens permitted to request information on the training provided to police officers? And how are Black people ever going to trust the police, starting with the Rodney King incident? Where do we go from here? And if you can just pass it on down.
By the way, among those many other luminaries that hang on the walls of Judge Dankoff's courtroom, he forgot to mention one. Judge Dankoff has spent part of his childhood in Sacramento, California. He's a very loyal San Francisco Giants fan. Hangs the picture of the greatest baseball player who ever lived, one Willie Mays. So if you ever get a chance to get down there and see this gallery, make sure you find that one as well. The traffic stop, listen, there's a big problem in this country of being pulled over, as Judge Dankoff talked about his case, for the offense of driving while black. And we all know it. It exists. I represented a member of the Baltimore Colts football team who got pulled over in wonderful Preble County, Ohio. And there is no question in my mind The reason he got pulled over was the kind of car he had and absolutely driving according to all traffic laws. Unfortunately, in his case, there was a little whiff or an odor of marijuana when the window came down. And that was enough then of a pretext for it to escalate to another charge. And which gave them the ability to bring him in and to search his car. Hopefully, the answer to the question somebody asked about, can they search your car? If they observe some kind of evidence of a crime, yes, they can. If they have arrested you, for example, they have taken you out and given you some sobriety tests for an OVI stop. And by the way, you don't have to take any of those tests. You don't have to do the heel to toe. You don't have to touch your nose. You don't have to follow the pen. You don't have to do any of that. But once you do, and they have enough evidence to say, I'm going to arrest you for OVI, then they may search the interior vehicle in the area in which you can reach. And that is a new pretext for their own safety. Beyond that, they need to have a warrant, for example, to get into the trunk of your car or any other locked compartment that is not reachable by you, the driver.
And Dave, can they search your car once they take you out?
There's another set of requirements for that. And that's called an inventory search. And that's if they tow the car, then down to the police station, again, for their own protection. Because if someone is taken in and they have your car, they don't want that person coming back later after they've been released on bail or whatever, and then coming back and says, what happened to the $1 million in cash that was in the trunk of the car? So no, they have to have an inventory with a witness, and if they find something during that inventory. But if they don't take the car in and you've left it for a family member or somebody else to pick up, or it's somewhere safe and secure for you to get upon your release from jail, then no, they're not allowed to get back into the other parts of the car. So again, I'm talking to a group of folks that I totally understand when I, given the color of my skin, are telling you that you ought to take it, you know, when you're pulled over by a police officer. But I'm reminded of John Lewis's lesson. You know, if you're walking over the Edmund Pettus Bridge with John Lewis, that's the time to get into good trouble. When you're all alone and a police officer's pulled you over in the middle of the night, that's not the time to get into good or bad trouble. Take it, go with it, and trust that people like these people sitting to my left will take care of it later.
Pass it down. We'll treat both of those as closing comments from you guys. Judge Jackson, anything else you want to add to this? And of course, we could go another 2 hours talking about what the old Jim Crow was, what the new Jim Crow is. We never got to that, but that's okay. Is there anything you want to add on this?
No, I mean, I am the very, very newest judge on the court. My first day was January 9th after being a lawyer for 18 years. I'm really glad that Judge Dinkoff talked about the concept of procedural fairness with the background of practice that I come from, as well as my life experience, I guess you could say, for lack of a better word, that is really, really, really extraordinarily important to me. And I am, through this process, as I am new and I'm learning, that is very much at the forefront of, you know, my priorities is making my court one that the community perceives as fair, because that is what fairness is. And so I just thank you all for allowing me to be here this evening.
Okay, Nick does not hang in my courtroom. He hangs in my chambers. Okay, along with Bill Russell, my heroes. There's no, well, yeah, Mazarowski. Anyway, so I guess we get stuff in chambers, so come by chambers sometime, you'll see something that I really like, which is Mexico City, 1968. John. Right? And I would encourage to put that. So there's a line. So courts, we said this before, they're your courts, okay? And I know Senator Roberts, my old friend, had to say, you get the chance to serve on a jury, jump at it. It'll be one of the greatest life's experiences that you ever had. You get a chance to serve on a grand jury, do it. You'll thank me for it, I'll thank Judge Jackson for it. It'll be one of your great life's experiences. Don't pass it up.
One of our takeaways tonight is it matters who the judge is on your case. I hate to say that, justice is equal and fair, but you want a judge that's a good listener and has a good fundamental understanding of fairness. Dave Williamson, as a practitioner, is one of those kind of people. Everybody knows Tom Roberts is that kind of person. And what I've learned when you put a panel together, get 4 people that are smarter than you and know what they're talking about. And so let's give them all a big hand. President Ford, thanks for the opportunity to do this.
Thank you, Attorney Lefkow. I actually have a question from one of the constituents online. And so I want to ask this question because they text me about 3 different questions. So I'm going to only ask one. And I've tried to ask which one is their most pertinent question. And I will ask this question because this one came up, I guess, several times. Considering that lawyers are not to eliminate a potential juror based on race or gender, can you talk about how juries actually reflect the demographics of this area? So meaning, our city is comprised of about 52.6% Caucasians and about 38.5% African Americans. So when you're in your courtroom and there's an African American inside of your courtroom, what is basically the demographic makeup that you normally see at the time that person is in your courtroom?
Judge can talk about this as well, but you have to keep in mind, we're common pleas judges from Montgomery County. Right, so we're countywide, we handle all the felonies, bad stuff, the murders, the rapes there. I mean, that's what we got, okay? And a jury pool in the city of Dayton and the Dayton Municipal Court would be considerably different because of the voter rolls for the city of Dayton and the voter registration for the city of Dayton. You would be much more likely to see people of color on the jury pools in the city of Dayton for a misdemeanor case. When you get countywide, it would be less so. Although one of the reasons that a couple of years ago, we went back to what was done in the old Senator, which was we had driver license and voter registration. For the longest time, when I came on the court, it was just voter registration. And finally, we decided that, that wasn't good enough. So we put the driver's license group back in there to do what? Get more representation from prospective jurors of color, and it's worked. So we have more jurors of color now in the county juries that we had. Do we have, is it always reflective in every single case of the demographics of the county? I would say not, but it's better than it used to be. Anyway.
And again, I started on January 9th, so I'm gonna pass it.
Just wanted to add, there's one other court too, that federal court. And these are common pleas judges. I also have practiced extensively in our federal courts. There, the jury of your peers, if I have a criminal case and I've had them in the federal court in Cincinnati, federal court here in Dayton, also federal court in Columbus. The Southern District of Ohio is Columbus, Cincinnati, Dayton, and pretty much every county south of Interstate 70. So now if I've got a black defendant from Cincinnati, we're in the federal court in Cincinnati, and I'm going through that jury pool, and here are folks from Marietta, from Portsmouth, from Claremont County, from way out in the rural counties of southern Ohio. Then you really are struggling to find a jury of your peers, but peer, which is an old English phrase to begin with, it is, as Tom suggested, it is the district in which you live and is arbitrarily written. So sometimes it's not so much, even if you followed all of these provisions that have been put into the law to try to get a fair jury panel, you just can't legislate against people's prejudices when they walk in for jury. And you're faced still with that problem.
Well, maybe we could, work with some laws on this, change laws that currently. To the. Is my. And several civil rights people's opinion that I have spoken with over the years, as you know, during my 60 years as president and going to probably national conventions for 18 years of the NAACP. That is a very serious question when you have individuals that get into court and they see people who do not look like them on that jury room. And that's very problematic. So there may be something that we can do as a civil rights organization in terms of changing laws on events. State Boston versus so first of all, I want to say, let's give Attorney Level, Chairman Level, then secondly, I want to say, let's give our panelists. Yeah. And thirdly, I want to say that Judge Dan Caldwell, I want to look you out for another. And I want to say we appreciate your courage. So we appreciate that. And then lastly, as we know, there are about 4 of you who are in the room there. There's council, there's Cleveland teams, there's not here. And Derek Scales, even though I administer the open office to 2 of you, Derek Scales and Stacey Vincent Taylor, I administer the open office to 2 of you meeting last Monday. Since we have the newest, she keeps saying the newest, see if she would administer the open office, to these new so there's nothing that. Yeah, so I have a script here. So the script is. Oh, here you go. So the skills. I know it's for you all, but I think it could be a good is still online? You still still online?
Yeah, he's online.
Okay. If you could unmute, I mean, if you could show your face and then come up. Forgetting that he was at the actual inauguration. Forgetting that. Yeah, so you two can come over and then Kaylin. And you all need to go this way because we can't see you in the back. Come over just a little bit more. I'm seeing, I'm looking. Okay. And then came to see you and, you were at the station as well. Okay, you three were not at this station. Okay, so let's see if we can have the, Angelina Jackson, it means your overall to you. Oh, no, I was not here.
You said here. You called out.
Okay. I state your name. Do solemnly affirm to discharge to the best of my ability the responsibilities of the office of. Do solemnly affirm to discharge to the best of my ability.
To solemnly affirm to discharge to the best of my ability.
Hands up.
The responsibilities of the office of state your position.
Responsibility of the office of executive.
In the Dayton unit of the National Association for the Advancement of Colored People.
National Association for the Advancement of Colored People.
In accordance with its constitution and bylaws.
Accordance to its constitution and bylaws.
And the decisions of its governing bodies.
And the decisions of its governing bodies.
I will also support the Constitution of the United States of America.
I will also support the Constitution of the United States of America.
I dedicate myself anew to its principles of equality.
Dedicating myself anew to its principles of equality.
And justice under the law.
And justice under the law.
I shall find my ways to keep the goals of the NAACP. Above any purely personal or individual interests that might hinder the attainment of those goals. I ask the continued help of the Almighty God in this pledge.
I ask the continued help of the Almighty God in this pledge.
Okay, congratulations.
Congratulations to you.
All right, well, thank you very much, John. We have a quick, administrative overrides. And next month, we will have, our recommended meeting will be on communications, press and publicity. And, so our new chair of that committee, which is Nicole Smith, will be chairing the meeting next month. She had come up with her own topic, just like Attorney Ludlow came with his own topic, and will have her own distinguished panel. And we're going to talk about communications, press and publicity, the word, to the general public. So with that, until the next time, may the Lord bless you, may the Lord bless the NAACP, may the Lord bless the United States of America. Thank you very much, everybody.
Thank you very much. Long time since I sat down there.